This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law. I'm Josh Block. Jose Cuervo Tequila and Maker's Mark Bourbon have been battling it out in court in a trademark dispute over red dripping wax seals on their bottles. Earlier this month, the U.S. Court of Appeals for the Sixth Circuit ruled that Maker's Mark's red wax seal is protected trade dress. Chris Sprigman teaches intellectual property law at the University of Virginia School of Law and is a regular contributor to the Freakonomics blog, where he wrote about this case. He joins me now. Chris, this lawsuit began in 2003. Why was Maker's Mark suing Cuervo?
Maker's Mark was suing Cuervo because they saw on Cuervo's Reserve tequila, a very expensive bottle of tequila, actually about $100 a bottle, a dripping wax seal in red wax that looked a lot like the red dripping wax seal that is at least reasonably famously on the Maker's Mark bourbon bottle.
This was a limited production of the Family Reserve brand of Cuervo. Was Maker's Mark just firing a warning shot?
This Reserve tequila was a pretty small batch of tequila. I don't think the tequila's in competition with Maker's Mark. I mean, tequila and bourbon are very, very different. They're sold at a very different price point. Maker's Mark is about a quarter per bottle of what the tequila costs. So I don't think there's a notion that people who thought that Cuervo's tequila was somehow connected to Maker's Mark might buy that tequila instead of Maker's Mark. The theory here is that people might be confused about sponsorship. They might think that the company that produces Maker's Mark was somehow connected to or was sponsoring this Reserve Cuervo tequila. I guess that's possible. The question that I always have, and this is a question that comes up a lot in trademark law, is so what? What harm does that actually create? Not clear to me that if I were in the market for tequila, I would be, altogether happy with the idea of, a connection to a bourbon company, since tequila and bourbon are completely different and made with completely different processes. Maker's Mark expertise in bourbon doesn't translate to me into the promise of good tequila.
Prior to reading about this, I would have assumed that the red wax seal served some functional purpose. It must seal in the goodness of the aging of the mash in the charred oak barrel. Is the seal functional, or was it just an aesthetic element?
Yeah, so the court didn't think it was functional. There was a debate over something called aesthetic functionality, which is not like regular functionality. So you can imagine the function of the seal being to as you suggest, seal the bottle. And I'm familiar with Maker's Mark, actually, maybe a little bit too familiar with it. I really love it. And the bottle cap in Maker's Mark is kind of essentially it's a cap that doesn't need the seal to stay fastened. So I don't think the seal actually serves a functional purpose in the standard sense. The seal might serve an aesthetic function. That is, it might be a feature of the packaging that's so attractive that it gives Maker's Mark a significant competitive advantage. But the court didn't think that the cap served that kind of function. It's not important enough to the marketing of the liquor to be aesthetically functional under the trademark law. And I think that's probably right.
The importance here is that if it's functional, the trademark would not be valid?
Exactly. If it's functional, things that are functional are really within the domain of patent. Trademark doesn't give you rights in functional things. It gives you rights in source identifiers that don't have a function. If you're going to get some kind of IP right in a functional thing, it's got to be because it's patentable. And, of course, the standards for patentability are very high.
The red wax seal causing customer confusion was one of the important issues here. How does the court make that determination?
The court uses a series of factors that are typically referred to by trademark lawyers as the Polaroid factors. And these are a series of inquiries into, for example, the strength of the mark and the similarity of the products and the proximity of the products, the similarity of the sales channels, evidence of actual confusion. So there was no evidence of actual confusion in this case. The court found that there was a likelihood of confusion based on these other factors, which are kind of indirect evidence of the likelihood of confusion, like the strength of the mark and the similarity of the products. Reading this opinion, it seemed to me that I was unconvinced that there would be consumer confusion about sponsorship. But, the important thing, whether I'm convinced or not, isn't really important. The important thing is that trademark law actually has a very weak set of tools in general for determining whether consumers are likely to be confused. A lot of trademark cases are essentially exercises in speculation about the likelihood of consumer confusion. This is a great example of that. There is no hard evidence. There is no actual evidence of consumer confusion. There's just kind of hints.
This case doesn't have a practical effect on Cuervo. They stopped using dripping wax red seals 6 years ago.
Yeah,
but if you were advising a liquor company, what can be done with wax seals without violating Maker's Mark's trademark now?
Maker's trademark, the actual mark that they registered, claims a dripping wax seal. They don't limit this seal to the color red, but I think very wisely in litigation they limited their claim to a red dripping wax seal. They said that they were limiting their trademark claim to red seals. So what I would advise clients is, first of all, straight-edge wax seals are not within the ambit, or should not be within the ambit, of Maker's Mark trademark. Straight-edge wax seals are traditionally used in a lot of different applications for alcohol. I mean, port shippers, for example, have often sealed their bottles with straight-edge wax seals. So if you want to use wax, I mean, I guess it looks classy. If you want to use wax, go for it. Go for a straight-edge seal. Red might be a little bit of a risk in that it's not a dripping seal, and so it's not the same as Maker's Mark trademark, but it's similar enough that you could imagine an aggressive trademark lawyer working for Makers claiming that they essentially own straight-edged red wax seals. Now, if they made that claim, I would like to be the defense lawyer because I think that's a winnable case of the defense, but it's not unimaginable that they would. There's something interesting though about the dripping wax seal, which is what is the message that the dripping wax seal sends? And I think the message it sends, which is probably for bourbon a very, very valuable message, and this is why I think the dripping wax seal is a really good trademark. The message it sends is, this is handcrafted. We arrange this wax seal by hand. This isn't some machine seal. And so that, I think, sends a message more broadly about the quality of the liquor. And this is reflective of the power of a good trademark. I think the Maker's Mark brand has benefited greatly from the communicative power of this trademark.
One of the things that the media focused in on with this case and about this opinion was that Judge Boyce Martin, Jr., writing for the unanimous three-judge panel, began with a quote from Supreme Court Justice Hugo Black about Kentucky bourbon, and that led into what Above the Law called an epic 6-page discussion of the history of whiskey.
He says one thing about bourbon versus scotch, and it really struck a chord with me. I never understood, and this is my own blindness, I'm aware, I never understood what people found in scotch. To me, bourbon is just far the superior drink, cheaper generally. And what's happening with Maker's Mark is a tiny little slice of what's happened with the bourbon market generally. The bourbon market has gone super premium. There's wonderful small batch makers. And, of course, their branding is very, very important.
You've written a lot about what's right and wrong with our intellectual property laws, and I think you've tipped your hand here, but do you think that the panel got this decision right?
On aesthetic functionality, I think they got it right. And on the likelihood of confusion, I guess I would say it very carefully. I can't say they got it wrong. I can't prove them wrong, but the evidence of confusion is very, very thin. And I think this points up something about trademark law, which is, trademarks are not rights in gross, right? They're not property rights in the normal way that you have property rights in, for example, a table. Trademarks are tools. They're tools to identify the source of products, and the trademark owner is able to prevent others from using a similar mark only when there's a likelihood of consumer confusion or a likelihood that a famous mark will be diluted, which is a whole other cause of action. But they're not unlimited property rights. They're, at least on paper, fairly carefully circumscribed. One problem, though, is that the trademark law has never developed any particular powerful methodology for determining whether an unauthorized use of an identical or similar mark is likely to confuse consumers or to dilute consumers' ability to relate the trademark to the trademark owner's product. Those are interesting empirical questions that the trademark law has never really grappled with. This is something I talk about a lot when I teach trademark. trademark is, at its basis, a set of empirical propositions that can be investigated, rigorously. The law, on the other hand, is populated with people, lawyers, who have virtually no empirical training in most cases, don't have a taste for empirical inquiry, and so what they do is they develop proxies for consumer confusion. I think these proxies generally don't work very well. And the Maker's case is an example of this. I don't know what the right result is, but I think the panel doesn't either.
That's Chris Sprigman, law professor at the University of Virginia School of Law. For more information about this and other topics, subscribe to BloombergLaw.com. You can find our recent programs on our YouTube channel. Follow my daily updates on Twitter at JoshBlock560. Thank you for listening.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.